Welcome to What You Really Want to Know. I am attorney Amanda Shaffer. Today we're going to talk about the new rules just announced by USCIS that reverses the Trump era asylum applicant rules related to employment authorization documents. That was a mouthful. But before we get to that today, quick reminder, don't forget to like us and follow us on YouTube, Instagram, Facebook, wherever you are watching from. Doing an early live today. Got a busy day ahead of us, but if you find this video helpful or know someone who may find it helpful, make sure to hit the share button as well. So today we're going to talk about this announcement that came out last week from USCIS. So quick background, when the Trump administration was in office, they had changed a lot of the rules relating to getting a work permit or employment authorization document if you've applied for asylum. They made it much stricter and made a lot of people ineligible. Then there was a series of court challenges. Some of them struck part of the rule down, some struck the other part. They were conflicting. There was a lot of confusion over the past couple of years because these went into effect in 2020. And then when Biden came into office, they started to change them back. And there was a court that ruled that they were in violation of the law. And now USCIS has came out and formalized it. So there's a lot of important things to note, especially if you're someone out there who may have applied and were denied, or received a request for evidence, a notice of intent to deny, and you're not sure if you are eligible or not to get a work permit to work lawfully. So that's what we're going to talk about today. Now, there's a bunch of things in it, and this actually goes into a little bit also into asylum eligibility. This was, again, all in one announcement, so I'm going to cover everything that they covered. First thing, and if you're watching on Instagram, you can't see my little subtitles, or not subtitles, I guess they're captions, whatever they're called, little headings. There you go. But I will put some captions up later on. So hopefully you can follow along for now. So the first thing is that if you look at the current version of the form I-765, which is the form to apply for your work permit, whether it's an initial, renewal, replacement, it's going to look the same. It's going to be dated on the bottom 8/25/2020. You're going to continue to use that version of the form until there is a new version to use. Now, the reason I wanted to point this out is because when you look at the form, there's going to be some questions on there that no longer apply. And we'll get to those in a second, but you still have to use that form. The second thing, CASA and ASAP membership is no longer needed. If you are unaware of what CASA or ASAP membership is, do not worry about it. But essentially, there was a court case that there was two groups that sued. And if you were a member of this group, you either didn't have to pay a biometrics fee, or some of the provisions of the law that are now struck down didn't apply to you. So basically, one of them was free, one of them was a few bucks. And if you submitted proof that you were a member, you didn't have to show about your entry. You don't need it anymore. If you have it, great. It can't hurt. It doesn't hurt, but you no longer have to become a member to avoid a biometrics fee. You no longer have to become a member of one of these groups to avoid proving that you entered lawfully or surrendered yourself to immigration authorities within a certain period of time. The next thing, under the old overturned regulations, we went from a 180-day eligibility period to a 365-day. What that means is you come to the U.S., you file your asylum application, you have to wait 150 days before you can apply to get your work permit. They can't issue one, so you can apply 150 days after they receive it, but they can't actually issue it until 180 days after they received your asylum application. Under the old rules that we just changed, you had to wait a full year. So they changed it from 6 months basically to a year. We're back to 6 months. So you don't have to wait a full year after applying for asylum in order to file for your work permit. I kind of mentioned this already, having to do with biometrics. So biometrics are your fingerprints and your picture. If you file for your initial or renewal work permit now under as an asylum applicant, you no longer have to go and do your fingerprints. Again, this is how it was pre-2020. The biometrics fee was $85, and this was even applying to initial applicants. That's no longer there. You do no longer have to go and do a separate biometrics appointment. Now, if you filed for your asylum, you do still have to go to your asylum biometrics appointment, which is completely different. You should have done it way before you file for your work permit anyway. But if you get a biometrics appointment, no matter what it is, whatever it says on top, I-5, I-89, I-765, my suggestion is go to it. It can't hurt. Worst comes to worst, they tell you they don't need, go home. But it's always better to do the biometrics appointment, even if you don't think you need to. I've had clients been asked to go a second time. It's better not to miss it and have something denied, but just so you know, these are two separate biometrics appointments. The next thing is, if you applied for a work permit prior to these new rules taking effect. So technically, everything I'm talking about right now is supposed to backdate to February 8th. But like I said, that's when the court struck it down. USCIS literally put these changes out last week. So you may have filed your work permit application as an asylum applicant and had it denied, or sent a notice of intent to deny or request for evidence. So if they're asking you in the request for evidence or the notice of intent to deny some of the proof that you no longer have to show, for example, your we'll get to criminal convictions in a second, but I already talked about your entry. So let's say you didn't enter the country lawfully with a visa. Before, they were denying it. They were saying, well, you need to prove that you either entered with a visa lawfully, you went, or you immediately surrendered basically to immigration and were then given parole into the country to pursue an asylum application after you passed a credible fear interview. You no longer have to do that. However, if you applied and you received either this request for evidence or notice of intent to deny, you need to reply. Don't just ignore it, let it get denied, and then refile. They're saying you're going to have more delays. So basically, they said if you reply and say, you're asking me for something that no longer applies, I'm eligible, they're supposed to now grant it. And they are telling people to reply instead of ignoring it and refiling it to prevent delays. So do that to prevent delays. It makes sense. They already have it. Just, send a letter back saying, hey, all you're asking for is things that no longer apply, basically. The next thing is, as I said, the latest form version that you're going to use is the August 25th, 2020 edition. On that version, if you're applying as an asylum applicant, there are a few questions that says, when did you enter the country? Well, everyone has to say when they enter the country, but did you enter through lawfully through a port of entry? If not, why not? Explain, and then provide this additional evidence. That you don't even have to answer anymore. Not only do you not have to file the evidence to show that you entered through a port of entry or surrendered yourself, I think it's within 48 hours, and were given parole or given a positive credible fear interview. You don't even have to answer the questions, so you can leave those blank. They will, I'm sure, have a new form soon, but until then, you leave those questions blank or put N/A for not applicable. If you are eligible, you are eligible for an EAD or a work permit, even if you're applying for asylum more than 1 year after entering the U.S. Again, pre-2020, this was the rule. If you applied 10 years later, 15 years later, you were still eligible for a work permit. In 2020, they said, nope, you got to apply unless you applied for asylum within a year of entering the U.S., you're not eligible. That is no longer the case. So you're once again eligible to apply for a work permit, again, you're technically eligible to submit the application 150 days after you file your asylum application, and after 180 days, they will issue you one, no matter how long you've been in the U.S. before you apply for asylum. Next change is that any criminal acts or convictions do not bar you now from getting a work permit. Again, this goes back to pre-2020, although it was always discretionary if you were going to get a work permit. They then made it clear if you had an aggravated felony, which I'm not going to get into that definition right now, but basically you committed a serious crime of some sort that falls into a certain category, then you couldn't even get a work permit. And if you committed criminal acts that make up the elements of the offense, even if you weren't convicted, you could be prohibited from getting a work permit. That is no longer the case as well. So if you were worried about that, you can still apply for your work permit. The next thing is that your work permit is not automatically terminated when you're denied. So if you apply for asylum and it gets denied, you're either in lawful status still, or more likely not in lawful status. If you're in lawful status, so maybe you're a student or something, or you had your interview very quickly, then your asylum will get denied. You're not getting referred to immigration court, and instead of your work permit terminating immediately, it will terminate 60 days later. If you are referred to the immigration court, then your work permit remains valid. And then if you're denied asylum, even though you're technically supposed to leave right away, if you're denied asylum, because that would mean if the immigration court denies it, you have an order of removal, then your work permit will stay valid until the expiration date on your work permit. This does give you a reason to renew it, even if your individual hearing is coming up, which I'd always recommend, because especially these days when hearings get changed all the time and without notice, it's always better to renew it than not renew it. But that's another important thing to know, that you won't automatically lose your work permit. If you timely appeal, of course, it remains valid, and you will be able to renew it past the expiration date as well. And another thing, it used to be, and this pre-2020 as well, if you lost your asylum case in court, appealed it to the BIA, as long as you timely appealed, your work permit remained valid. If the BIA denied your appeal, even if you timely appealed that to the U.S. Court of Appeals, you no longer could renew your work permit. Now you can. If you lose in the BIA and you timely appeal to, if you're in New York, the Second Circuit Court of Appeals, then you still have a valid work permit and can renew it when it expires, which is a change, and an important change. Next, this was something put into play right before Trump administration came in, and then they took this away, which was the 30-day processing requirement for initial work permit applications. So basically, they're reinstating this, and that means that's a great thing for anybody who's waiting for their work permit, initial at least. Their USCIS is supposed to issue them now within 30 days of applying. I'm sure it'll take a little. They were doing that. They were pretty good at it for a while, but hopefully they'll get back into that. Hopefully the renewals they'll start approving as quickly as well. But they reinstated that 30-day period, which means they should be cranking them out a lot faster, which is very helpful for people waiting to be able to work legally. Another important change is that work permits for asylum applicants are no longer discretionary. What does that mean? That means if you apply for asylum, you waited your 150 days or 180 days, then you're eligible. They can't deny it because of criminal convictions, because they don't like your face, because whatever reason. You're eligible, they have to grant it. You at least can work lawfully and renew it until your case is able to be heard. Now this, again, the last two things that I'm going to say, they're related to applying for asylum, but not necessarily work permit related, but was all in the same announcement. So a lot of people were having an issue where you'd apply and then for asylum within, the time period, and then a month later, a month and a half later, you'd get it rejected. Your entire application would come back. And there was a time where it was as simple as you didn't put in a not applicable or an N/A into one box, even though they weren't supposed to deny it. But they waited so long, and then there would be a lot of stress that even though if you resubmit it, you're supposed to get the date that you first submitted it, if it was just something like that caused the rejection, but obviously it caused a lot of stress for people. So what they decided to do, and I think this is a fair thing to do, that USCIS has 30 days to either issue you a receipt notice or reject it and send it back to you so that you can complete it and then send it back to them. If they do not send it back to you within 30 days, they have to consider it submitted and complete. And if you were missing information or evidence that would have been a reason for rejection, they can then send you a request for evidence. But you no longer have to worry that 2 months later you're going to get it rejected, and then what do you do? So again, that's a big change that I think is really important, because I know for me personally, every time, it doesn't happen that much, but it was happening where we'd submit application packages for clients, and it was really frustrating when 2 months later it would randomly come back sometimes for no reason at all. Honestly, we'd fill it out and I wouldn't understand what the rejection was. But it happens with other applications too, but it is with asylum where timing is so important and the stress that goes along with it. I think this will be very helpful for people. And then finally, all evidence that is submitted before or during the asylum interview must be considered. Now, this is, again, something that really technically always should have been the case or was the case. I don't know if they're more or less clarifying it. But what this means, what they specifically said, is some people, if you hire us, for example, to do it, we try to submit everything we can with the initial application. But sometimes we have clients come to us 2 weeks before their 1 year deadline, or they come to us and they're just not able to get certain evidence and they want to just get it filed because they want us to be able to work legally, or they want at least, they know how long the wait can be, that type of thing. So you really get 2 chances initially to submit evidence, one with the initial application, and then you can bring evidence with you to the asylum interview. And what would happen sometimes is that the asylum officer wouldn't take the time to review the evidence the client brought with them and just decide not to grant it and refer them to immigration court, or they would have to delay a decision, and the delay would take months and months and months. So what these new rules say is the asylum officer, if you bring in a bunch of evidence with you, you're allowed to do that. And if they can't interview you now because they need to review that evidence, they need to postpone the interview, just reschedule it. And again, this is something that makes sense because, they should review all the evidence before they interview you in order to ask you the right questions. And then they're also saying that the asylum officer should grant you an extension of time to submit additional evidence at the interview. If you walk in there and didn't know that you could have brought additional evidence, you say, oh, I have this, then they should give you an extension and a new interview. The only thing to keep in mind is if you have not hit 180 days yet since your asylum application was filed on your clock, that might be considered an applicant caused delay and stop your clock. It won't start again until you go to your interview. depending on how long it takes them to interview you, this may or may not become an issue for you. If they start to speed up the interviews again, where people were they were supposed to have them within 30 days, this will be something that could affect you if you were to extend time to submit evidence. Otherwise, if you've been waiting for 3 years, obviously this doesn't apply. So again, it's always best to submit all the evidence up front before you go to your interview to prevent any processing delays, to prevent any postponements of interviews, to make sure that you don't lose any eligibility or pause your eligibility for anything like a work permit when it's possible. So I always stress you should go see a lawyer at your earliest ability, and we can help you make sure that you can do your best in doing that. So that was a lot that I kind of put it all in there together about these changes. But basically, just to recap real quick, in 2020, the Trump administration changed a lot of the rules related to eligibility for work permits for asylum applicants. The courts have gone back and forth, striking down certain provisions and upholding certain provisions. And the Biden administration, or I should say the court officially back in February, one of the courts kind of said this is, all goes against the rules. We can't have this. And then we waited to see how USCIS would respond and what the new requirements would be. And that's what came out last week. And that's what you really want to know talked about today. So if you go back and watch it, you will, if you're just tuning in now, I went over all of the different factors, all the different provisions of this new change, or these new changes that came into play. A lot of them go back to the way they were pre-2020, if you are aware of those. Otherwise, there are some other changes that are making it easier, not harder, easier for someone who has applied for asylum to get a work permit. And then, of course, there were a few rules at the end related to applying for asylum to make it a more fair process. So that is all today for what you really want to know. If you have questions about applying for asylum or for a work permit for asylum, if you are watching on YouTube or Facebook, our contact information scrolling across the bottom of your screen. On Instagram, if you go to our bio page, our contact information is there. We'd be more than happy to help. Make sure to hit that like and follow button so you don't miss any more of our lives. And if you found this information helpful or know someone who may, please hit that share button. Thank you all for watching and have a great day.